This employment law video is on flexible working. Eligibility to make a request under the statutory procedure. Employees must have at least 26 weeks continuous service with the employer to be eligible. Employees can only make one request in any 12-month period. Making a request. In order to make a request under the statutory procedure for flexible working, such as a change in hours, a change of place of work, or a change of when working, for example, an employee must make their request in writing, date the application, state that the application is being made under the statutory procedure, state the change to the working conditions they are seeking and when the change is to take effect, explain any effects on the business and how the effects could be overcome, state whether they've made a previous application under the procedure and the date of any previous application. How must employers handle requests? Employers must handle requests in a reasonable manner. ACAS, the Advisory, Conciliation and Arbitration Service, has provided useful guidelines in what is reasonable. In terms of timescale, the employer must give its decision on the flexible working request within 3 months of the employee's written request, although it could be extended if agreed between the parties. An employer can refuse a request for one or more of the following business reasons: the burden of additional costs, an inability to reorganise work among existing staff, an inability to recruit additional staff, a detrimental impact on quality, a detrimental impact on performance, a detrimental impact on the ability to meet customer demand, insufficient work for the periods the employee proposes to work, and a planned structural change. Remedies under the statutory procedure. An employee could, subject to time limits and the early conciliation process, bring a claim in the employment tribunal on the basis that the employer had made a decision on incorrect facts or had failed to follow a proper process. This could include, for example, if the employer had rejected the application for a reason other than a permitted reason. If a tribunal upholds a complaint, it could make an order for reconsideration of the request, or it could make a compensation award up to a maximum of 8 weeks' pay, or it could order both, informal requests and other potential claims. There's nothing to stop employees from making informal flexible working requests, and there's no minimum length of service required. Employees who make requests, whether formally or informally, could have other potential claims, such as for discrimination. That's my video on flexible working. And the usual legal caveat that this video is for guidance only and should not be relied upon for specific advice. For more information, visit my website. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.